Thank you, Rasmus.
Thank you, Diego. And now we're ready for the CBN webinar on IPR. We already had one on how to work with governments and putting the culture and creative industries on top of the agenda. And next time it will be, as I mentioned, on reading and learning. But today we have some really great people and some really good cases that we will talk about. We have an hour, but I think we can actually cover a lot of issue if we follow the rules that was just set out by Diego. First of all, we have Christina Wainikka, who is a Swedish national, and she was part of the Creative Business Cup Global Finals jury in 2016, if I remember correctly, maybe even before that. And so she was part of the jury selecting the winners of the Creative Business Cup. She's now part of the Swedish Confederation of the Swedish Industries, where she helps with IP issues. She's going to be my co-host today and run most of the webinar. Then we have Chioma Ogudimkpa. I've been practicing that last name for a while. Chioma is from Nigeria. She participated in the Creative Business Cup last summer, 2019, and won the CBC Africa Award. She has a fashion company called Red Button and is very successful in being widely copied all over Africa for her fantastic design. Then we have Johann Kreuter from AWS. Johann Kreuter is not an IP lawyer, but he is someone who knows the connection between business and why you should protect your IP. AWS is the Austrian Wirtschaftsservice, the Austrian Enterprise Service. It's actually an economic development bank, and AWS has been our partner through many years now, and our Creative Business Cup national partner for Austria, helping creatives in Austria to grow and excel. And last but not least, we have a good friend, I have to admit that, and also on the board of Creative Business Cup Foundation is Jesper Moseholm, who has two roles. He is married to the woman, the ceramist, Anne Black, and he's also CEO of the company called Anne Black. And Jesper will tell about a case where he's been copied by a low-cost retail chain and the implications that it had for his business and for Anne Black, his wife, and the company. Yeah. So I will now give the word to Christina Wainikka, who will give a presentation and then lead on to the rest of the presenters. So Christina, you're welcome to elaborate also on what I told about you. Maybe it wasn't enough or precise enough. I can't remember if it was 16 or 17, but anyway, you're welcome. The floor is yours.
The scary thing is that I actually can't remember which year it was. So I'm Christina Wainikka, and as you understand, I'm a lawyer in the field of intellectual property rights. And the Confederation of Swedish Enterprise, where I'm working right now, we are an organization with 60,000 member companies. So I'm trying to help them with questions on IPR, and I have a background as a legal researcher and also as an entrepreneur. And I'm going to start off with three cases from a Swedish perspective, Elflugan, Konken, and Simon Stålenhag. And I can't seem to shift the slide. There. So, Elflugan, this is a type of lights that we in Sweden often have up in our windows at wintertime. And when this design came out, it was more or less revolutionary because the lights didn't normally look like that. So it was a tremendous success. Everyone had one. But of course, there were copies made, and they actually took it to court. And they have won several court cases because there have been several different copies. But one sad story was that the first case actually took to court, the first case that they won, then the copycat put themselves into bankruptcy, so they didn't have to pay the damages. So that's a really sad case. So you can win, but you can lose. Another example of a Swedish success, which is also a success internationally, is this backpack, Konken. In January, me and my husband, we were in Istanbul, and it was quite interesting to walk around in Grand Bazaar and different places in Istanbul. And there were Chanel bags, and then there were Fendi bags, and there was Konken. And Konken was already quite popular when I was a child. And the problem is that, of course, it's very good for them to be an international success, but the copying does actually, even if this is a rather big company, affect their profit. So year after year, they have had problems with these copies. They have people working full time on handling all the different types of copies. And then we have the example of Simon Stålenhag. And Simon Stålenhag is a Swedish artist. So he makes sort of dystopian paintings. And he has experienced that people are taking a lot of inspiration from his paintings. And this is a newspaper article claiming that there's a computer game that sort of stole his characteristics from his paintings, which is of course a problem for him because he created sort of his world. Another interesting thing about Simon Stålenhag is that his art has actually been the foundation for a television series in the US now. So he's sort of transformed his creativity into something else as well. So with those three examples, I'm actually going to start with the core takeaways. Because the thing is that if you are successful, there will be copycats. So that's sort of the backside of being successful. The problem with copycats is that they can either be infringements, so sort of copyright infringements or trademark infringements. And if they are infringements, then you will have the legal tools to go to court and get damages and prohibit them from continuing and so on. But the problem is, like in the case with Simon Stålenhag, is that sometimes they are just considered as lookalikes. They are inspired by, and we can sort of more or less everyone knowing the original can say, well, they were clearly inspired by, but they are not within the scope of intellectual property rights. So they are just lookalikes. And the problem is, of course, that if you take that to court, you're going to lose in court. And you will also have to pay for the entire court proceedings and everything. So it's important to know the difference. But the core takeaway is as well, if you're going to handle things with copies, you have to prepare yourself. And that is something that preparation should start early. So if you're aiming for success, you should also prepare for the copies because they will be there if you are successful. So setting out the legal framework when it comes to the copyright protection, there is an international perspective on intellectual property rights, especially copyright. So you have a Berne Convention, which is implemented in 178 countries in the world. And you have the right, there's no registration, so you have the right. The problem is, of course, that there are going to be questions. We were first, there is no protection, we acted in good faith. When it comes to preparation, I would say that the most important thing is that you make the necessary agreements. For example, if you use freelancers, document the steps of the creative process so you can prove later on that these were the steps in the creative process and the dates when that happened. Communicate your right by using the symbol C, the copyright symbol. And if you can use other rights, for example, trademarks, do that so you have more rights than just the copyright. And first of all, do actually act, do communicate, because if you don't do that in the beginning, it will be more difficult to do that later on. And there I'll stop.
So, Christina, you can unmute and take over from here. Next in line could be Chioma, and you are welcome to then ask a few questions after Chioma's presentation. Chioma, do you want to go ahead? I have unmuted you.
Yes. Okay, awesome. So I'll just share my example. Can everyone see my screen? Can anyone see my screen now?
Yes. Yes, we can.
Awesome. Okay, so this is, okay, thank you. Right, so my name is Chioma. I am the founder and creative director of Red Button. Red Button is a sustainable fashion brand. We are based in Lagos, Nigeria. I am also the African Prize winner for the Business Corp 2019, like Rasmus has said. So it's really, really offered us opportunity to grow our business and reach other markets. So thank you to the CBC. All right, so going forward with the topic, clearly what you see is a copy of what we created in 2018. It's very unpopular in Nigeria that people actually take you to court for copyright infringement. It's really unpopular here, and that's majorly because of education. A lot of people don't even understand the implications of what they do. Now, even when they copy and you write them that this is a copy of my work, just like I did with this case, right? So the copycat actually sends a message, or actually published, that the reason for her copying was because she wanted to totally appreciate the work of art, right? She wanted to totally appreciate the work of art, and she didn't feel like she needed to change anything. She wanted it to be in its entirety, to look exactly like what I have done, because she totally loved it. And that was her excuse of copying. And to make matters worse, she said that I should be proud that she's copying my work verbatim. So that was quite ridiculous. And I felt like so at that point, I wasn't even upset about this copy. It was just a case of ignorance. So she's not even aware of the implications of what she has done. And that actually goes far as, all the countries in Africa. So a lot of people have realized that they're not even aware of the implications of what they do. They just copy because I feel like it's nice. I can do that, right? And it's making money. She's selling loads of copies. I might as well just make a copy and also sell. So a lot of it is out of ignorance, right? And so that's our current reality. We're not really aware of our IP rights in this side of the world. And even people that are aware, it's a bit more difficult to pursue those rights because of the bureaucracy that's within our system, right? So again, I'd rather have, if a big fashion company copies a small fashion company, they'll typically be copying the designs rather than the trademark, their logo, their symbols, their names, and what have you. So in that case, the small fashion company is left to wonder, okay, so why am I pursuing this big fashion company when they really just copied my design and not, I don't have my logo on it, I don't have any trademark on it. All right, so that's another issue. Fashion companies need to be aware of what they need to do to protect themselves. And in general, the Nigerian fashion industry is almost $8 billion industry. And it's so interesting that an industry that's so valuable is not really doing nothing about protecting the rights of its stakeholders. And it's so pathetic at this point because we are growing exponentially all over the world. Had companies, designers from Africa showing, selling out in numbers. But the problem is we really do not know how to protect ourselves and our designs. And that's where education comes in. And then this is our reality, really. The major takeaway for fashion companies or fashion designers will be to understand the benefits and the merits of trademarking or copywriting or patenting their work. So these goes as far as creating a more robust or a more high brand value for your brand. And also, it's also essential that you commit your brand value or your IP rights or your IP registrations to your customers and even investors. So for someone like me, So Red Button is pretty much a new brand. We're just about 3 years old. 2 weeks ago, we clocked 3 years 2 weeks ago, and we filed for our trademark. It's been almost 1 year now. So these are some of the issues because of the long process it takes. So a lot of fashion companies don't even bother, and that's a huge problem. So, but because I'm aware of the benefits of registering my company or trademarking my design, it's also it's become a critical part of my process that I should do that, because of course I'm looking at what the brand value will be at the end of the day, or maybe in 10-20 years time. All right, so this is a major reality in Africa. Companies need to be aware of the benefits of registering their brands or their designs or their logos and or what have you. And then the next thing will be educating every stakeholder. Like I said before, it boils down to education, because a lot of people see these things as normal, especially in this side of the world. So it's normal for me to copy, it's normal for me to replicate, because I know nobody's going to chase me. I mean, they're selling out, I might as well just copy and sell out. So if people are held accountable for the wrong things that they do, or even knowing exactly that this thing that they're doing is wrong, I'm sure it will go a long way to to help our growth. I mean, the industry is growing exponentially. Why exactly are we leaving out this protection side of our work? So the critical takeaways will be educating the stakeholders on why this is critical, and of course educating the fashion companies on the benefits and the merits of having their IP rights secured, and of course generally how having stakeholders communicate their brand value, communicate their IP rights, so that these things don't happen. When people recognize this design and logo or trademark or what have you as your brand or as your property, a lot more people will be more loyal to you, and this is what is lacking. That education part of it is what is lacking, and that's exactly the main takeaway for me in terms of IP rights. Thank you,
Chioma. Actually, I have one interesting comment. Is actually the situation is almost the same in Sweden and in other European countries, actually, especially when it comes to the level of awareness. So that's actually one of the things that I'm working the most with, even in a country like Sweden. And I was actually at a seminar in Finland in November, discussing SMEs and intellectual property rights from an EU perspective, that the level of awareness is not actually there. But is there anything, if you go through creative education, is there any teaching on intellectual property rights at all? Did they teach you strategies on how to protect, for example? Is that covered in your education?
Yeah, exactly. So we have, no, actually, it's not covered in the formal education. However, it's covered in the curriculum for fashion students. So if I register to a fashion school, it's covered, right? So if I don't register to a fashion school, my regular curriculum in the university or in any formal education doesn't have it at all. All right. So because I went to a proper fashion school, I had that curriculum there.
Yeah.
So also there are other informal hubs that teach creative people how to protect themselves. So apart from those informal hubs and the fashion schools, we don't really have them in the formal curriculum. Yeah.
Because I actually think that perhaps training should be done even earlier. For example, South Korea, they have education already in lower school, so that is covered by everyone. And I actually think that could be a good idea for more countries to have that earlier. Actually,
definitely.
Because actually, I think that the level of awareness that you're discussing, I think that also needs to be with the customers, so that the customers start to look for the originals.
Look out for these originals, exactly.
Yeah, and if that is covered in school, that could be helpful.
I'm sorry to interrupt. We have to move on to Johann, but I just want to say one of the last countries I visited before the world closed down was actually Nigeria and Lagos. And I just want to make you guys aware that besides Nollywood and a booming and valuable fashion industry, it's the city in the world where you drink the most champagne per capita. And it's also, if you want to learn more about this culture, you can go in on Netflix and watch a series called The Bling Lagosians.
The Bling Lagosians, yes, exactly.
It's initiated by Bolanley Austin Peters, who was actually scheduled to come to Copenhagen this summer for the Cup,
Creative Business Cup.
But she will come next summer for sure, and also we'll do some online activities with her as well. But now I think we should give the floor to Johann Kreuter from the Austrian Wirtschaftsservice.
Thank you very much. Yes, like you say, Rasmus, before, I'm an engineer. I'm not a legal professional. And engineers always thinking a lot about protecting their invention. And they had to, because it's really expensive. The likelihood is it's really likely that they never get their patent because of the state of the art. And maybe the development is not in the focus later where the patent is. So it's very expensive, and they had to think about where to put their patent exactly.
Could you just in one sentence describe the difference between a trademark or copyright and a patent, just in one?
So in one sense, okay, we engineers have the trouble in the beginning. It's really expensive, and you don't know where to put your focus of your IP right. Copyright give the creators right under copyright just by creating something. It's cheap in the beginning, but as Christina mentioned, it's really difficult later when you take this to the court. So this is one difference, but the overlap is that it's all about business. It's about the business model. Nobody copy inventions or designs, they copy success, as Christina mentioned before. So the focus of, and I want to talk today, I want to emphasize the IP strategy. And IP strategy is always directed to the business model itself, to the success, where the money comes from. The problem is that it's really easy to copy great features from a product, than inventing them yourself or put reputation yourself, of course. If you see legal instruments like patent, design, copyright as tools, you can see IP strategy as the use of these tools for a strategic purpose. This purpose can be make ideas tradable, exclude someone from the market, communicate that you are inventive, or even give it away. You need rights to do that. So you decide what to do with your tools, with your design, with your intellectual property rights, but to have them first. It's not enough, and it's not enough to have them. You have to use them, of course. So my first point I want to raise is that IP strategy is an approach to avoid competition for cost and for low prices. If I may say that in this Anne Black case, this supermarket chain is really good and competing at low prices, low cost and prices, of course. But Anne Black is really good in creating value, in designing ceramics. And the advantage Anne Black had is that this creators right under copyright, but they have to enforce this right, of course. Second point I want to raise about IP strategy, that IP strategy is always looking for the exclusive, a competitive advantage in the market. Focus on that. It's important for engineers. I mentioned that before, but maybe it's also important for fashion designer, creative industry businesses. If it is this red dress we saw before, this really beautiful dress draw attention to the woman wearing this dress. It gives her a feeling of uniqueness, for example. IP strategists would now try to understand why the customer, why this lady put money on this product, why she spent a lot of money on this product. He would try to understand why she do that, and if it is the exclusivity, he would advise them to put a unique identifier on that, like Chioma said before. Maybe you need a trademark, a sign, something, and maybe she needs to educate her customer first to see the difference between her dress and the dress of the copycat. So then the third point I want to make about IP strategy is that this is an investment in your innovation. It secured investment in your innovation. That's IP strategy. You use tools, but you use it in a way. And there are many different measures to do that. Of course, there are patent, there are a trademark, there are design, non-registered design, and so on. I would like to focus on the non-informal measures to protect your ID. And I have brought a list. There are many of them, but some of them can be, you have a very close customer loyalty. Tell your customer a story, give them a good reason to buy your product. Then the effect is the same like a patent. You have some kind of exclusivity. What you tell your customer could be labor standards, social welfare, trade your employment's very good. The value proposition is now not the dress or something, it's now something more. And they can buy this exclusive because of your product, of your strategy, so a close customer loyalty. Then have the best team. They are great IP if you can keep them. IP is their knowledge in their head. And if you can control, or if you have a good team, you have really good IP. Then be always one step ahead. First mover advantage. Copycats would copy product versions, the old one of your product versions, and customer would recognize the difference, of course. Then pay attention to the interfaces. The interfaces is the things between something. In this Anna Black case, if I understand that right, there was the compilation of things. Not the cylinder itself, it was the compilation of the weight of the three parts. And if you if you cannot protect one thing alone, stand alone, maybe you can protect the the compilation, or maybe the connector. It could be yes.
Yes, you're over time. But it's music to my ears, because you actually sort of emphasize what I said and come with more information. And actually, I would like to comment on the last thing, and that is to think of it as a tool, but the entire toolbox, and build packages. So
Right.
that means that sort of these intersections, they could use, for example, protection for business secrets, because the protection for business secrets, you can protect the why. Right. Why have I chosen these colors? Why do I communicate with my market in this specific way? And that is especially important when it comes to, for example, service innovations. We had received a question on training programs and how can we protect training programs. And we can actually see that we have international companies selling sort of services and protecting them through trademarks, copyright, and trade secrets, like the training program Zumba, for example, or the music teaching program Suzuki.
Yeah,
so you have the level of different protections, and then also important, the agreements. So the agreements that you make with the ones using your service or your training program.
Thank you very much. Yes, of course, trade secret is the next one. And you should use all of them. They are team players.
Exactly.
Put them together.
Packages.
Packages to your budget, fitting to your budget and your needs as a business, of course. And contracts, yes. We're very similar. There are similar things that inside. So, and even my last point, IP strategy is primarily communication. As Christina said before, be prepared. I would like to talk about the step before you take actions. You never attack someone directly. First, you threat or warn somebody if you want to attack him. And if you are lucky, the accused one stop doing illegal activities because of you threatening. but you have to be clear and you have to be credible. And in this kind of communication, there are 4 points where this communication can fail. One, you have mentioned that before, is that the infringing party is not aware of of their infringement. They don't know that. So you have to tell them clear and in clear words, and all of them, of course. Yes, you have to be clear. And one point can be that the competitive.
Thank you, Johann.
Okay.
You can get your points again at the end where we do a quick round. I want to make sure that we also give the floor to, let me unmute, Jesper Moseholm, who is the husband of the ceramist Anne Black and the CEO of the company Anne Black. You can go on anneblack.com and see some fantastic designs in ceramics. It's not just, so to speak, pots and mugs. It's also jewelry and lots of other things that you can see in Anne Black. But Jesper, please let us hear about your story of Anne Black versus Netto.
Okay, thank you very much. Actually, it raises. I really want to. It gives me an opportunity to comment a lot about what you've already said, because Denmark is one of the countries in the world, as I understand, who has the most protective law system in place for protecting IP rights. But at the same time, it also has the most effective copy system in place for infringing those IP rights. And so, for instance, just to comment quickly on your hand, is it okay to comment, or do you want to hear the whole story? I can do the story very quickly. Oh.
Remember that no one knows your story, Jesper, so maybe you should just do a brief 2-minute presentation.
Okay, the story starts in 2004, where this grocery retailer copied Anne Black the first time. We solved the problem with a out-of-court settlement, a very small amount, and then we rest the case. And then 12 years later, they do another copy, but this time they copy 3 products. Both times it's one of the best-selling products, and in this second case in 2016, it's more damaging to Anne Black because taking 3 products from her collections kind of circulates in her brand, so it becomes more clear for the customers that this is Anne Black, and they don't really understand why she's selling her products in Netto. That was basically what it looked like. So we started a case. Netto is a really, really big player, and Anne Black obviously is quite small. And this case has been running for 4 years, and it's been quite challenging to talk honestly. It's cost a lot of money. We paid around 150,000 euro to do the case in lawsuit cost, and a lot of additional internal time. So basically, I would never recommend anyone to do what Anne Black did if you look at the size of the company, because it's too risky. You may fall into bankruptcy before you finish the trial. That's basically the situation.
You went from 11 to 2 employees, right?
We kicked out all our staff in Denmark, and 18% in Vietnam. We lost 85% of the turnover in Denmark. I would say the company is, close to terminating. I mean, it's been a literal, very, very, very bad situation for the company. So
you maybe want to say that you won the court case.
Oh yeah, we won the court case in 2019. After 3 years, we got one of the biggest compensations in Denmark historically. We changed the practice of the law. We got brand into the practice of the law for the first time in copy cases. So yeah, you could say we ended up successfully. However, they appealed the case, and now we're up for the next court in next week. And as far as I can see, the only strategy they applied was to see if they could kill Anne Black along the way. They knew before they launched the product that they were going into trouble. Their own lawyers warned them. The Chinese company who copied the product warned them. I mean, everybody, everything was on red alert before they actually launched the product. They knew exactly what was that it was wrong, but they still did it. And that brings me back to what Johann was saying, and basically your whole discussion, because of course you can prepare but you just have to understand that even if you prepare the guys who is copying, they are better prepared. So if you look at this situation with Netto, they run these campaigns weekly. So within a week, they're already onto the next campaign. So within a week, they basically destroy your brand work in the country by, you know, making a mass marketing approach with a discounted copy product. So you can't really, you don't have time to respond before the damage is already done.
So the damage is not only the fact that they sold something you could have sold, but they actually destroyed the brand.
They didn't, you know, they published the material to pretty much any household in Denmark. So they use your brand work and your product design, and then they put it into their mass marketing work in order to attract customers. So you can see here, the whole thing about this case is it's not so much product driven in the sense that this grocery retailer wants to go into the porcelain market and sell nice copy products. They use it as a marketing, it's a marketing tool. And because they use it as a marketing tool, you know, some of the things the previous talkers talked about doesn't really help you a lot because it's so fast. It's like, you know, it happens in almost a second. So in that respect, you can't really prepare. However, I would still say that there's a lot you can do to prepare some of the things we already mentioned. But on average, if you look at the copy cases, you should have an insurance. So you should have a lawsuit insurance, so you can get some support if you actually decide to do the case. But overall, we all have a responsibility, and Anna Black was one of the ones who took really big responsibility here. We have to do the cases. We have to go to the law system. We have to, I mean, we can only change the practice of these copycats if the law is preventive. And if you look at Denmark, the law has not been preventive. We got 20,000 Danish kroner, that's roughly 3,000 euro when they copied us in 2004. In October last year, they offered us 200,000 euro to do the same type of settlement. So you can see, you really need to you need to step up the amount. Otherwise, it's not preventive. Netto has been copying other companies along those years. I don't know how many, but Anna Black is definitely not the only one. And every time there was a case starting, they paid out between 3,000 to 5,000 to 8,000 euro in settlement, and then they could move on to the next product.
Yeah. And we can say that is quite similar to the case Elfluga that I showed. So they have been widely copied, and they've won several court cases. But as I mentioned, one of the copycats went into bankruptcy themselves, not having to pay the damages.
Yeah.
So there are big problems, and to give another sort of scary thing, in some countries, for example Sweden, the disputes on intellectual property is exempted in the insurances.
Yeah.
So you can take any other type of cases to court with help of your insurance, but not intellectual property cases, which is terrible.
So that's why I wrote in when I was asked about a statement for this seminar. I said we need some unified responses. We need some organizations which are, you know, the ones the copycats are looking at when they decide what to copy. Because initially, I'm sure that Netto and the sub-supplier, they didn't really believe that Anna Black could do anything about this copy. And obviously, it's also been quite a bit of a challenge. But if Anna Black was organized in an organization who had the power and the strength to actually do the cases on behalf of Anna Black, then you would see another picture. And you have to understand that what Anna Black did here does not concern only Anna Black. It's the verdict we got is important for anyone working with IP in Denmark. And that's why we're also now backed by one of the biggest labor organizations in Denmark, Akademikerne, which represent 425,000 professionals, as well as some of the commercial organizations like it's called Dansk Industry. So some of these big players in Denmark, they're actually aware about the importance of this. But we've been standing alone for 4 years, and actually it's pretty crazy to think about. But you know, this little ceramicist, she had to spend all her money to change the practice of the law, which may hopefully, if it's concluded the same way next week, benefit other people. But how come the society is not capable of making these obvious and necessary changes in order to protect IP-related businesses?
And I think that is actually one of the key issues, and one of the things that I'm working with where I'm working now is to raise the awareness also from the policymakers, from the society, so to say, that these creative industries, they are creating profit and GDP for the countries. So they have to be protected and helped, because otherwise we won't see creativity.
If we look at the GDP, I want to mention another thing. This grocery retailer claimed they made around 20,000 euro on doing this campaign, and a black made 20 million euro during her career. She's on a long-term path building and managing a company, which they literally tried, maybe not on purpose, but literally risked damaging by this infringement in 2016 and the continuous lawsuit. So this is definitely not good for the GDP.
So you're saying, Jesper, you were talking about we need something on organization, but you're talking about like a weapon of deterrence, so that they will say, oh, they're organized, so we won't go after them, like a way that that will discourage people from copying.
Yeah, the problem now is the best business idea you can get in Denmark right now is to copy. I mean, it's a better business to copy than to do the actual product. I mean,
and that is, of course, damaging in the long run. That won't serve anyone in the long run. We have a question from Annemette. Shall we send?
Yes, we have Annemette Demøller from the Danish Artists Association. If you could identify yourself by raising your hand.
Yes, I'm here.
There you are. There you
Thanks
are.
a lot for some interesting words from all of you. And I just have a specific question to the ideas, how this went along when you realized that Anne Black was copied. Was it like was it more items, more ceramics, or just one, and then it turned into 10 or whatever? How did it evolve? How did the process go? That's one thing. And then secondly, what did you do? You said you should insure yourself. Looking at it from a perspective afterwards, you said you should insure yourself. What did you do to actually get into contact with the organizations, artist organizations, and also some insurances or whatever? How did you process?
Well, I'm not sure I understood the first question, so let me start with the last one. Along those 4 years where we've been in this case, we've actually been in contact with a lot of the various organizations, creatives, and also more business-related organizations. I haven't been in contact with you, but we have been in contact with other organizations, and they've been aware of the issue. And recently some of them actually stepped into the case and is standing in the court next to Anne Black now. So in that way, you can say we are getting some support in this late part of the lawsuit.
Maybe I can just share my screen so everyone can see what we are talking about.
But I wonder, what was the first question? I didn't really understand that. The one about 1 to 10 products. What?
Go ahead, Annemette.
Oh, she lost.
Oh, sorry. I'm unmuted.
Yeah.
Now you're on.
Could you repeat your first question, Annemette?
Can you hear me now?
Yes.
Yes, fine. Yes, the ceramics, did you, from at the first, did it start just one? Like, I know your ceramic bottoms and many of your cups and designs and so forth. Did it start with just one thing, from Netto? Or did it just kind of, start with one thing and then turn into 10?
Well, Netto just only copied Anne Black 2 times. First time it was just one simple product, and then the last time here in 2016 they decided to copy 3 products. And the fact that they copied 3 products made it into a more severe case for Anne Black, because it was just, I mean, people who know the brand would confuse. They wouldn't know why they can buy Anne Black products in Netto at 10% of the original price. So what we could see is, yeah, I mean, a response to your question would be, we've seen a deterioration. So even though everybody talks about how to improve the protection of IP, if you look at Anne Black, you see a complete failure of this system to protect, because they were able to copy one product in 2004, and then 12 years later, they're actually deciding to do a much more complicated and damaging infringement. So, seen from the perspective of Anne Black, we're going in the wrong direction.
Do you regret that you took the legal way, Jesper?
No, I think I will always be proud that Anne and I had the courage to do it, because, you know, there's been so many other companies, including ourselves in 2004, who has allowed and then enforced this copy practice by not actually doing the lawsuit. There's only one way to stop this, and that's taking the guys to court. And then the court, of course, has a responsibility. They have to make some verdicts which have a preventive character. So anyone who make these out-of-court settlements, they're encouraging the copycats to continue, at least as long as the amounts are so low, so they just calculate it into the budget of the marketing activity.
We now have about 10 minutes left of this very, very interesting discussion, and you're welcome to write questions in the chat if you have some. If not, we also have a long list of questions from you guys that you posted when you registered, and we could take either some of those, or we could take some that you post in the chat. It's up to you. If there's anyone that has a question to Chioma, to Johann, Christina, or Jesper, then go ahead. It doesn't seem so. Then maybe you, Diego, could read off one of the first questions we got on beforehand.
Yeah. Actually, there's one question I would like to start with. Actually, 2 questions, because they're linked together. One question was, what can I do when I use freelancers? And the other question was, how can I sort of pay in an early stage? And those could actually be linked together. So when you're working with other people, you will have to make agreements to ensure that you are the right holder. Like, for example, in the Anne Black case, if there is a dispute in court, there might be a discussion who actually created this. And if you have been working with other people, will first have to prove that you actually hold the right. So I imagine in Anne Black's case, that was an easy part. But in other cases, that might be difficult. So then you will have to have the agreements in place. So do that on an early stage. But in the early stage, it might be very difficult to come up with the money, because you don't really have any money, because you've not started to earn any money yet. And there in intellectual property rights, there is a system for balancing those interests, and that is the royalty. Meaning that you can write the agreement, not paying everything up front, but making the agreement, when we start making money, you will be starting making money. So therefore, you don't have to write agreements and paying everything up in front. You share the risk, so to say. And I think that's an important perspective. So sometimes I meet people that they don't write the agreements early on, because they say, we don't have the money yet. But then they're taking a great risk. It's better to write the agreement and then share the risk through the use of royalty. That's one answer to one of for 2 of the questions.
May I come in here from the
Yes.
engineering side? You're talking about licensing, a license, an agreement about a license, and upfront payment is a good idea to take the risk in the future. Another way is to see a license like a cake. You can put this cake in parts, territorial, in time, in grade of exclusivity, and of course in application specific things. If there is a software developer and he's an expert in image processing, of course he would not give all of his work to you because you give me a small project, and you cannot have all the right of my big software imperium. Let's say I need that for my work. And so we would talk about what exactly is the application, in which how you to use it, how is the distribution channel, grade of exclusivity, and you will get a small cake of this big cake, but that one you use for your business model. And this is often a good approach if you talk to a freelancer what you really need, not talk about is this my work or your or my rights or you, but talk what you need exactly and get paid for exactly what you really need. Even if it's a small part, it's cheaper, but it's that what you want. Okay.
I also we heard Chioma say that it takes a long time, and you said then, Christina, it takes just as long time in Sweden. Doesn't that favor those that have the money and those that have that can actually do it? It's difficult to be resilient when you're small and just starting up and an SME.
I think so, but on the other hand, for example, we had two companies in Sweden that were sort of famous for making copies, IKEA and H&M. But I think in the public view, they were quite sort of shamed for doing so. So they have big design departments now, so they're not making as many copies nowadays. And actually, we have court cases in Sweden where H&M has taken other companies to court because other companies have made copies of H&M design. So I think it's sort of also important with the level of awareness with the customers. Are we as customer accepting copies or not?
That's kind of like
awareness important.
It's almost also Chioma's point that if her customers could shame those that copy, but that's not really the case. Those that copy say that you should be proud that they copied it. But if you could have a more like a moral rearmament when it comes to copyright, that would be good. I always find it interesting how people will not accept a copy product like a bike helmet for their children, or that some parts of an airplane would be a copy product from not from the right source, because then they would be afraid. Stuff like that is
not to scare you, but we have a Swedish company, SKF, that are making parts used, for example, for airplanes, and they have a lot of problem with piracy. Not to scare anyone. I don't like to think of it when I fly, but there's actually the situations. They are also being copied, which is quite scary.
And it's all part of the same story, I think. And a black place, and also Chioma, and what we heard today is a lot about, well, it's different whether it's a spare part in an airplane, I know, or whether it's a fantastic red dress. But it all is about us wanting to be creative, inventive, come up with new ideas, new solutions to both what we wear and where we go and what we do. I think if we don't uphold a good copyright protection and also use of copyright, then society will not be where it could be. I think it's really important for all of us, and also to protect the creative work, because otherwise we would leave it all to IKEA and H&M of what we would wear and what we would surround us with. And although I have IKEA stuff, and I probably also have some stuff from H&M, I would be sad if that was the only thing I had to wear and to look at. So it's really about the whole economy that is at stake here. We have about 2 minutes left. Do we have any additional questions, or do we just want to take a round of points from you? We could start with Chioma, then go to Jesper, then Johann, then end up with Christina. If you have one last minute advice to the many creatives that are listening in here.
Okay, great. So from my end, it will just be to ensure that we all as much as we are creative, we understand the business side of what we do, especially for people who are swamped with being just creatives. I have a lot of those in Africa. We're really just bent on creating and innovating without protecting ourselves. As much as we are interested in creating, we should also invest in securing ourselves and protecting ourselves, with our IP and educating. Importantly, we talked about it. Christina also talked about it. Communicating your rights and ensuring that your customers also buy into your products or into your brand value and understand the reason why they're buying into that. So that if there's a copyright somewhere or an infringement somewhere or a copy somewhere, they immediately know that there's a copy and this is a copy. So that comes with a lot of education, a lot of awareness. Yeah.
Thank you. Yeah, and Jesper, some last word of advice. You need to unmute. Let me unmute you.
Oh yeah, okay. Sorry. Well, I already said it that I think we need those more unified responses because we can't rely on each creative individual to manage this. This is quite a tough system to engage with. So that's my point of view.
Excellent. Johann, I will unmute you.
Yes, I would say business models wear out. And the same is for intellectual property rights. So your creative entrepreneurs fill your pipeline.
Excellent. Christina.
Yes. First of all, that IP issue should be part of both the business strategy, but also the marketing strategy, because that's when you communicate with your customers. So think of how can I use even the marketing strategy to communicate about my intellectual property rights. And also one thing is to actually work together and discuss with others, because that can make us stronger.
Excellent, thank you. One of my takeaways is about education, and it's first I thought, well, we can't expect Anne Black and Chioma and all the creatives to educate, but so I think there's two-sided. On one hand, it is a government responsibility or a public's responsibility to make the public aware of the importance of copyright. On the other hand, it's also important for Anne Black and for Red Button to tell its customers why their products are better and why how they can recognize that this is an original product from them. So to create, like Johann said, a loyal fan base or customer base that know that they get the right product, as Jesper said, so that they're surprised and they would know, no, that can't be Anne Black product that's being sold in Netto, because she would never sell her products in Netto. Also, one of my takeaways is, of course, that you have to be prepared, but sometimes you can't be as prepared as you think. When the big guys come in, then there's not much you can do. I hope all of you enjoyed this IPR webinar. We will have more webinars on Wednesdays in the morning at 9 o'clock, but also in the future in the afternoon, so we can also get the Americans to join us next Wednesday in the morning at 9 o'clock. It will be about reading and learning with some really interesting speakers that we will announce shortly. Now I would like to say thank you to, first of all, my executive producer, Diego Jaén, helping out, and then also to Christina Wainikka, Johann Kreuter, Jesper Moseholm, and Chioma Ogudimkpa. Thank you very much, everyone, and stay tuned for the next This is CBN. Thank you.